Hi, friends. Have you ever wondered if you're still eligible for a employment-based green card or a green card residency through your company if you had some kind of violation of your non-immigrant status before? You came to the right place. Stay tuned for all the secrets and we'll reveal them all throughout the show. Friends, welcome to Green Card Guys TV. I'm your host, John Ting, and you probably know this. I practice immigration law in all 50 states of America and all across the world, from the East Coast to the West Coast. Now, let's get down to the details here. We have some secrets to reveal to you. Of course, they're not secrets in the way that, we just found this in a treasure box, but they are in the law. But many people, many attorneys don't know about these secrets or this provision in the law. Now, for example, we've had calls about this many times, so that's why we decided let's put out a video on this. Some people have called in and said that they have been out of status for, let's say, 150 days or even 220 days. Okay. The kicker here is a 180-day mark. The first secret is yes, you can be actually out of status or have violated your non immigrant status for more than 180 days. So the trigger here is 180 days. If you violate your status for more than 180 days, you have to return to your country at some point, right? Here's a tip now. If you leave and you already crossed over the 180-day period, you will have a 3-year restriction. But here's the thing. We're going to explain that right here. It could be due to you working unauthorized for 180 days, or it could be some other kind of non immigrant visa violation, or overstay, fail to continue education through F1 status. Okay, so those are examples. Or you fail to, for the going to school, for example, that'd be failing to maintain your immigrant status, lawful immigration status. So those are examples because that's important for you to know when it comes down to it. You need to speak with an attorney. If whether it's been less than 180 days or not, here's why. Okay, to repeat again, if it's been a violation for more than 180 days and you've been in a country already the second time, and the more than 180 days was before this visit, your current stay in America, then that is waived for the purpose of employment based residency, green cards. Now, as for family based, that's a different conversation. Those have different tips, they just have different analysis that we have to go through as attorneys. But if you have violated more than 180 days in the past, but not based on this current non immigrant status, then that's okay. But if you are currently here and it's more than 180 days on this current stay, then you are not eligible for the residency or green card through employment based. Okay. Please follow the difference there. Now, re-mention this again. So, the three common violations of immigrant status are: you fail to maintain your status. For example, you were on here on F1 status and you just stopped going to school, you stopped paying tuition. That's one example. The second one is you're working here without a work permit. And an example of that, maybe you did have a work permit before, but then maybe you forgot to renew it, or even someone here on DACA and maybe forgot to renew it. It happens. Okay, and the third one is if you violate your non-immigrant status. All right, so those are the three common ways. But here's the deal. If you have waited the 3-year bar or the 10-year bar, for example, because those violations happened long time ago and you currently don't have any violations on this current stay, your current non-immigrant status, then yes, you are eligible. But even if you did violate your status, but it's less than 180 days during this current non-immigrant status stay visa, then it's okay. Okay, it's allowed by law. I'll provide a link to the page I just showed you. It's a uscs.gov page on the website. It's from the USCIS policy manual. So this is called 245K. Not many attorneys know about 245K. So that's why I want to share that with you. Now, here's a secret. Here's a bonus. And that is you're here on asylum or seeking asylum originally when you came into the country, or even when you filed after you entered the country and you didn't have any intention originally at the time of entering the country to file for asylum, your circumstances changed, your country conditions changed, where you're from, and even if you filed after 1 year. So the general rule is 1 year rule to file for asylum, okay, upon entry. But there are exceptions to that. But the point here, the secret, the bonus tip here is that filing for asylum, it has to be a genuine application. Bona fide is what they call it. That means it's real. It's a real, not a fake claim of fear, but if it's real. Of course, they have to go through the process for the interview, right? The immigration officer or judge to determine if you're telling the truth. We call that credibility, but it has to be a bona fide application for asylum. I know that was a long explanation, but here is a positive situation. It puts on hold unlawful presence. So that's why you have to file the application before the 1 year if you intentionally, your original intention is to file for asylum when you come in the country, or it could be after the 1 year if it's during your non-immigrant status. So for example, if you have filed for, or you're here on a F1 visa and things in your country, conditions have changed in your country, for example, Haiti as an example, or Afghanistan because the Taliban took over now, took over. So those are examples where country conditions change, and you can file during your status. But if you file without status and it's after the 1 year, that does not count. Okay, so that's different. If you have questions about this, I'm sure you do. You're welcome to contact us, or if you just have questions in general. If this is your first time watching our channel, welcome. Subscribe down below and click the notification bell so you get all the future notifications. But this is what I have to offer, friends. We have a free 15-minute preliminary discussion. But guess what? You need to show up to the consultation. We've had some people, unfortunately, schedule a consultation for the free 15 minutes and they don't show up. And unfortunately, if this continues to happen, we will have to remove the 15 minutes. And we really would love to offer this to you, to everyone who watches our YouTube channel and subscribes, because sometimes we do just have one or two questions and we want to point you in the right direction. So here it is. To access the free 15 minutes, we do have a secret code, and it's right here. Okay, friends? Green card guys. You could have guessed it, but you would have only known this if you watched all the way to the end. So here it is, green card guys. If you call in and expect the 15 minutes, but you forgot the code, you need to go back to watch the video again. Because whether it's our answering service or a cares team answering the phone, they need to have the code so they can help you, and they want to help you. If you have any questions about these type of scenarios, welcome to drop in the comments, but preferably we try not to speak about case-by-case situation in the comments below. But in general, if you just just need to be pointed in the right direction, we're happy to answer it in the comments, okay? But otherwise, if you have a specific case question, please give us a call or text us right up here, 346-330-5888. And we also are available on WhatsApp and Facebook Messenger. Until next time, friends, thank you so much, and please continue wearing your mask.